More than half of the states in the Union allow constitutional carry, which is the right to carry a firearm without a permit or license. While Tennessee claims to have constitutional carry, their Constitution places a but in that claim. A recent case in Tennessee Chancery Court asked whether two laws restricting someone's ability to bear arms is constitutional or not. So we'll look at this case next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your eyes and generation to be free. I'm glad you could join me today. Now, as you probably know, my adopted home state is Tennessee. I moved to Tennessee about 10 years ago, and I was pleased to get an email from someone I know in the area asking me to review this case. It was an interesting case, and as you'll find out, there's some good and some bad and a little bit of ugly in there as well. Now, if you want to check my sources and all my work, go to constitutionstudy.com and look up the article. I've got all my quotes in there with links to where I found them so you can double check my work. I'll talk more about the website and other things you can do to support the work we're doing here at the end of the episode. But for now, let's take a look at the constitutional carry in Tennessee. Several plaintiffs, all of which are citizens of the state of Tennessee, filed suit against the governor, attorney general, and other state officials, claiming that two state laws are a violation of the Constitution of the state of Tennessee. From the decision we read, plaintiffs seek declaratory relief from Tennessee Code annotated 39-17.1307A, the going arms statute, and Tennessee Code annotated 39-17-1311A, the park statute. These are both statutes that plaintiffs argue make it a crime to carry a firearm in a public place in violation of Article 1, Section 26 of the Tennessee Constitution. Defendants, however, challenge whether this court has the authority to grant such relief, whether plaintiffs have standing to pursue their claims against Governor Lee and attorney violations in light of the existence of at least one constitutional application of those statutes. Now, both sides filed motions for summary judgment in their favor. A hearing was held by a three-judge panel of the Chancery Court of the state of Tennessee, 28th Judicial District in Gibson County. Let's start with the facts of the case. At least one of the individual plaintiffs desires to carry a firearm in Tennessee's public parks, greenways, public recreational areas, and other locations enumerated in Tennessee Code annotated 39-17-1311A. At least one of the individual plaintiffs in the past has carried a handgun in places covered by Tennessee Code annotated 39-17-1311A. At least one of the individual plaintiffs in the past has carried a handgun in places covered by Tennessee Code annotated 39-17-1307A. There are two statutes in the Tennessee Code annotated that are a question in this case. The first is 39-17-1311, which is entitled Carrying Weapons on Public Parks, Playgrounds, Civic Centers, and Other Public Recreational Buildings and Grounds, or parks for short. And it reads, "It is an offense for any person to possess or carry, whether openly or concealed, with the intent to go armed, any weapon prohibited by 39-17-1302A, not used solely for instructional, display, or sanctioned ceremonial purposes, in or on the grounds of any public park, playground, civic center, or other building facility, area, or property owned, used, or operated by any municipal, county, or state government, or instrumentality thereof for recreational purposes." There are many problems with this statute. First, the intent to go armed. Why would someone be carrying an arm if they didn't intend to go armed? Could someone simply say, "Oops, I didn't mean to carry a firearm"? The second is why a statute to prohibit the carrying of prohibited weapons only in certain locations. Because Section 39-17-1302 states, "A person commits an offense who intentionally or knowingly possesses, manufactures, transports, repairs, or sells an explosive or an explosive weapon, a device principally designed, made, or adapted for delivering or shooting an explosive weapon, a machine gun, hoax device, knuckles, or any other implement for infliction of serious bodily injury or death that has no common lawful purpose." Now, at first glance, it appears that the prohibited weapons do not include firearms that have a common lawful purpose. However, as I understand it, the park statute has been used to charge people for carrying otherwise lawful weapons in parks and public buildings. The third problem, and the one that the court focused on, is the fact that the law effectively claims that public areas are not subject to the constitutions of either the United States or Tennessee. TCA 3917-1307 is an even worse violation. A person commits an offense who carries with the intent to go armed a firearm or club. Known as the going armed statute makes it a crime to go armed, even though the Tennessee Constitution says it's a right. Article 1, Section 26 reads that citizens of this state have the right to keep and bear arms for their common defense, but the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. How did the legislature square this circle? The Constitution of Tennessee says you have a right to keep and bear arms, but the legislature can regulate the wearing of arms to prevent crime. The legislature decided to regulate the wearing of firearms to prevent crime by making it a crime to carry a firearm or club. This is one of the reasons why I say Tennessee does not have constitutional carry, because carrying a firearm is a crime to which the Tennessee legislature has provided certain exceptions in subsection 1307. It is an exception to the application of subsection A that a person is carrying, whether openly or concealed, a handgun, and the person lawfully possesses the handgun, and the person is in a place where the person is lawfully present. Now, based on these facts, plaintiffs have avoided exercising their rights in the area the TCA claims to prohibit. And not because they believe the statutes are valid, but to avoid being detained, issued a citation, or potentially arrested. They filed this suit to be relieved of the restrictions on their rights. The court pointed out that the Constitution of Tennessee has protected a person's right to keep and bear arms since its first version was created in 1796, and that Tennesseans insisted on that right to prevent the abuses that occurred in England. The evil that was produced by disarming the people in the time of James II was that the king, by means of a standing army quartered among the people, was able to overawe them and compel them to submit to the most arbitrary, cruel, and illegal measures. Whereas if the people had retained their arms, they would have been able, by a just and proper resistance to those oppressive measures, either to have caused the king to respect their rights or surrender, as he was eventually compelled to do, the government into the other hands. The court looked at much of the legal tradition around Article 1, Section 22 of the Tennessee Constitution, including the power of the General Assembly under it. The court next examined what limitations the General Assembly could impose upon the use of such arms. It flatly rejected then Attorney General's view that the legislature was empowered by the second clause of the Article 1, Section 26 to prohibit absolutely the wearing of all and every kind of arms under all circumstances. To this we cannot give our assent. The power to regulate does not fairly mean the power to prohibit. On the contrary, to regulate necessarily involves the existence of the thing or act to be regulated. But the power is given to regulate with a view to prevent crime. The enactment of the legislature on this subject must be guided by and restrained to this end and bear some well-defined relation to the prevention of crime, or else it is unauthorized by this clause of the Constitution. The court also looked at previous decisions involving the Second Amendment to the Constitution of the United States, including several opinions of the Supreme Court of the United States. The court agreed that the power to regulate did not include the power to prohibit, which leads us to the court's decision about these motions for summary judgment. Accordingly, this court holds that the going armed statute violates the Second Amendment to the United States Constitution and therefore also violates Article 1, Section 26 of the Tennessee Constitution. With respect to the going armed statute, plaintiff's motion for summary judgment is hereby granted and defendant's motion for summary judgment is hereby denied. Accordingly, we conclude the park statute violates the Second Amendment to the United States Constitution and therefore also violates Article 1, Section 26 of the Tennessee Constitution. Plaintiff's motion for summary judgment is hereby granted with respect to the park statute, and defendant's motion for summary judgment is consequently denied. I find these decisions interesting. Yes, they are correct in that they violate the Second Amendment and they are therefore unconstitutional and void. For the foregoing reasons, plaintiff's motion for summary judgment is granted and the defendant's motion for summary judgment is denied as a result of the going armed statute, Tennessee Code 3917-1307A, and the park statute, Tennessee Code annotated 3917-1311A, are hereby declared unconstitutional, void, and of no effect. It is so ordered. What I find interesting is not that the statutes were found unconstitutional, but the logic regarding the Tennessee Constitution. This court has claimed that the statute violates the Tennessee Constitution not because of the language of that Constitution, but because it violated the Constitution of the United States. This brings up a conflict between the two documents that I've been talking about for years here in Tennessee. By claiming to place additional restrictions on a right protected by the Constitution of the United States, the state of Tennessee is violating the Supremacy Clause of Article 6, Clause 2. This Constitution and the laws of the United States which shall be made in pursuant thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. As these statutes were created by the legislature to regulate the wearing of arms with a view to prevent crime, they do not violate the Constitution of Tennessee, since these judges, like all other judges, are required by the Supremacy Clause to follow the Constitution of the United States above even their state constitutions. The ultimate decision to grant summary judgment for the plaintiffs is both legal and correct. I only wish that the conflict between the two constitutions was part of the decision. So there you have it. The Going Arms Statute and the Park Statute of Tennessee have both been found unconstitutional and void by a state court. Now, could this be appealed to an higher state court? Possibly. Wouldn't surprise me if it did. But it's good news. It's good information. Even with the fact that the court still doesn't realize that the conflict between the Tennessee and the United States constitutions and didn't really mention it, the good news is gun owners in Tennessee, you can carry your guns in parks and public buildings. And by the way, it's no longer a crime to go about armed, even though the law has these weird exceptions. It's just a weird setup. Maybe the legislature of Tennessee will see this and say, maybe we should fix this. We'll have to wait and see. However you look at it, if you live in Tennessee, it's good news. If you don't live in Tennessee, well, maybe this is something your state could emulate. Now, again, I've told you can find out more at the website constitutionstudy.com. You can follow my links, join a mailing list, maybe consider donating to the cause. You can do that at the store. You can also donate by using your cell phone. See, Patriot Mobile is America's only Christian conservative wireless provider, and they support organizations like the Constitution Study, meaning when you pay your bill, a portion of every dollar goes to organizations just like us. Now, if you'd like to join, go to patriotmobile.com/constitution, find a plan that works for you, see if you're eligible for a discount. And if you check out using the code Constitution as a promo code, you'll get your line activated absolutely free. Not a bad deal. So again, go to patriotmobile.com/constitution to find a plan and discount that works for you. And don't forget to use the code Constitution at checkout to get free activation. I also hope you'll come back and join us here. And hey, maybe bring a friend or two the next time we get together for the Constitution Study.
Love your neighbors and have a few good friends.